This is Barry Zalma speaking for Claims School Incorporated's blog, Zalma on Insurance. Today we're speaking about why a party seeking discovery in a lawsuit concerning health insurance fraud is entitled to receive anything relevant to a party's claim or defense. And a discovery attempt by alleged fraudulent healthcare providers failed in the district court because upcoding and healthcare fraud is important and not unusual. In a case entitled UnitedHealthcare Services versus TeamHealth Holdings, Inc., the United States District Court for the Eastern District of Tennessee on November 18, 2025, resolved a discovery dispute, which was simply a discovery ruling and not a decision on the merits. The disputes dealt with a fraud/RICO lawsuit brought by UnitedHealthcare and its affiliates against TeamHealth, a large physician staffing company focused on emergency medicine. The companies have a history of mutual litigation over billing practices, including prior suits where TeamHealth accused United of underpaying claims, that is, downcoding, and won substantial judgments in arbitration against United. Plaintiffs' claims are that TeamHealth allegedly engaged in systematic upcoding by submitting claims with inflated CPT billing codes that misrepresent the acuity and level of emergency services provided, leading to overpayments with simple cases such as indigestion billed as high complexity critical care. UnitedHealth estimated overpayments of more than $100 million since 2016. The causes of action in the lawsuit include common law fraud and negligent misrepresentation, violation of Tennessee insurance fraud statutes, Tennessee Consumer Protection Act and similar state laws, and federal civil RICO, 18 U.S.C. Section 1962C, and RICO conspiracy, Section 1962(d), alleging TeamHealth operated as an association in fact enterprise to conduct pattern fraud via mail and wire. The defendant's position was that they denied fraud, claims its coding is standard and appropriate, and argued that UnitedHealth's allegations rely on comparisons to other providers' coding rates, making comparator data relevant for defense, e.g., that is, to show TeamHealth's practices are industry normal, not fraudulent or indicative of a distinct RICO enterprise. During fact discovery, TeamHealth served requests for production on United, seeking 1. Coding acuity data, billing code distribution by severity level from Sound Physicians, an emergency medicine group, and other United-affiliated or Optum-related EM providers. 2. Documents showing the corporate structure of Sound Physicians and those other entities. TeamHealth's arguments were that Sound Physicians is partially owned by Optum, a UnitedHealth Group affiliate, since a 2018 investment. If Sound, allegedly United affiliate, used similar high acuity coding or similar decentralized corporate structures, it undermines United's claims that TeamHealth's practices are outlier, fraudulent, or evidence of a nefarious RICO enterprise versus just normal business. TeamHealth rebuts its intent and distinctness of enterprise and non-standard coding allegations. United arguments to counter that Optum's stake in Sound is a passive minority investment. United does not control Sound's coding policies, billing, or operations. Data from an uncontrolled third-party entity has no probative value on whether TeamHealth defrauded United. Magistrate Judge Poplin prepared a report ruling that the court should grant compulsion for United's own corporate structure and denied as to the request for production insofar as they sought Sound or other affiliated groups' data, because it does not make it more or less likely that the defendants violated RICO or upcoded. TeamHealth argued that the magistrate applied overly strict relevance standards. Comparator evidence is discoverable under broad Federal Rule of Civil Procedures 26b1. District Judge Corker applied magistrate judge's rulings and concluded that anything relevant to any party's claim or defense and proportional is even broader historical view that encompasses information that bears on or that reasonably could lead to other matters that could bear on issues, but not unlimited. No fishing expeditions are allowed. Courts may limit overly broad and irrelevant requests. The magistrate's conclusion that data from Sound was not relevant was not clearly erroneous nor contrary to law. The ruling found to be Sound is an entity United does not control. Its coding data and structure would not reasonably lead to admissible evidence on TeamHealth's alleged upcoding or RICO enterprise. The ruling limits TeamHealth's ability to obtain comparator evidence from United affiliated but not controlled providers. Diverse discovery continues on other issues, and the trial date has not yet been set, so dispositive motions are still due in March of 2025 per earlier orders. Upcoding allegations are recognized by the court as common defenses by payers against high-billing EM providers. The case remains active. This decision is purely a procedural win for United on one discovery front. This ruling is narrow and deferential, but typical for objections to magistrate discovery orders which are overturned only rarely. In my opinion, when dealing with attempted health insurance providers' fraud, resolution of discovery issues often resolves the entire case seeking damages for fraud or alleging RICO violations. The district court affirmed the magistrate judge's ruling and limited the use of comparator billing as a defense to the claim of fraud. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also gain access to the more than 5,200 blog postings. Please tell your friends and colleagues about this blog and the videos on YouTube and rumble.com so that they too can subscribe. They're free. And if you're interested in further details about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.